Hey, again, everyone, it's Rob Ryder, and today is Sunday, July 11th, 2021. Notice a constitutional question and subpoena. That's what we're going to talk about today. Before we get there, I'm Staff Sergeant Robert Allen Ratluski, Army of the United States. That'd be the big Army. Includes everybody that's able-bodied in the United States. And I am a United States Army veteran. You can call me Rob Ryder. My email address is quarterrecord@aol.com. And there's my phone number, 616-712-6179, because I have nothing to hide. And, so here last week, or last video, right, what I had, which, in case you're at this video, somebody sent it to you. My other videos are on Rob Ryder at YouTube, with 3 B's, ROBBB, RYDER. And if you were searching by upload date, you would see the last video I put in was called Faith is Esquire's Achilles Heel, which is a follow-up to the one previous to that, Lord's Prayer, and your hour of testing your day in court, in which I had related a couple of stories of things that I suggested over the last many years that I had done something in people's court cases, and they were nice enough to tell me about it. And the one in particular was this one here recently with Jackie in Florida, who was in a foreclosure case. And that she had mentioned in a comment on this Lord's Prayer video that, she had just recently gone back and looked at her records in her court case. Although the case is still open, right? There's been a mortgage that's been released, a lien that's been released, and there was something else that happened. I don't remember exactly. And Jackie, I've tried to contact you about this, sent you an email, and it didn't bounce back, and I'm sure I used your right email, but I haven't heard from you. So maybe you went to your spam file or whatever. But if you could give me a call, we're time to go to phase 2, see what we can do next. So that's what we're going to talk about is, well, what would you do knowing what you know now? What could you try differently? Right? And so, one of them is a notice of constitutional question, which is you file a notice in your court case, say, hey, I got a question about something, if something's constitutional. And another one is to file a subpoena, to ask for whatever evidence it is that they're saying that they have against you. So in a foreclosure, you would ask for the note and the mortgage that they say that they have a copy of. If it was a criminal case, well, then, prosecutor, I want to see all the evidence against me. Right? Because people never see anything when they go to these court cases. The information is being concealed. And even in a foreclosure, when they say that they put the note and the mortgage into the complaint, when you go and look at it, they've blanked out like the loan number and all sorts of details. We'll take a look in just a second. So, but what had come to my realization here recently was that now I can't speak about criminal cases with this, but let's just go to civil cases, right? In a civil case, the plaintiff's attorney is never actually serving you. They're only pretending to serve you, right? And the reason, or the way you can tell, is because in Jackie's case, months after she should have done something, the judge is still saying that she hasn't answered. Right? We were supposed to put an answer in within 20 days of being served. So if the judge is saying you still need to put in an answer, 6 months later, then you must not have been served. Because if you had been served and not answered, then the court or the plaintiff's attorney would have put in for default judgment and, not even bothered having a court case. That isn't what's happening. And so let me show you a few things easier to see when I show you the documents. So hang on just a second and we'll get started. Okay, so there's no real secrets to any of this once you understand what it is they're doing. And so in Jackie's case, you can go look at this yourself. The nice thing about this case is it's all online, right? So they got all the documents you can look at and everything. And you would go to Lake County Clerk's website, and there'd be a button there to push to go look at court case files or court case records. And you need to put in a case number, right? And so this case number is 35-2019-CA-001306. You put that much in, you'll find this court case. And this is the first page you come to, where it's the United States of America acting through Rural Housing Service, Successor Agency, blah, 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 blah. Well, we should really stop right there and think about this, that if it was the United States who had a claim against you, they wouldn't be coming to the state court. They would use the federal court. Right? So apparently this isn't really the United States. That was my first indication a long time ago. Well, there's just something wrong with this. Why would the United States use a state court? All right, and then if you look, there's all these different defendants. And you get Veazey, a.k.a. Jacqueline Victoria Veazey, a.k.a. Jacqueline Veazey, comma, Jacqueline V, right? That's a defendant. That whole name is a defendant, the full name of the defendant. Then you got Veazey, a.k.a. Jacqueline Victoria Veazey, a.k.a. Jacqueline Veazey, unknown spouse, Jacqueline V. That's a defendant. Unknown tenant. So there's something really hokey going on with these court cases. That if you're not looking at the record, you wouldn't necessarily know all this stuff was, there to be seen. And in her case, you can go under dockets, and then it lists all the different documents in here. And we can see that there was a complaint that was put on June 18, 2019. Civil cover sheet, summons same day. So it says, so forth and so on. So, okay, well, if they did that within 20 days, Jackie should have answered. If she didn't answer, she would have been in default. But, that's the background. Now let's go look at a copy of documents here. See what we have to look at. So here's the civil cover sheet that was apparently put into that case. And it's done by this form number, which is tied to the Florida civil procedures we'll look at in a second. Right? And it says in the circuit court for the 5th Judicial Circuit in for Lake County, Florida. Well, that really isn't the name of the court. Right? It's a bunch of words that has the name of a court in there, but it's, not the name of the court that has a court seal. And then it was this United States of America, blah, blah, blah. And then we have this whole thing here that's supposed to be supposedly the defendant. Lake County Political Subdivision, the state of, it stops there, state O, state of Florida. Well, what the hell is that? Department of Revenue. So, a bunch of nomenclature that doesn't really mean anything. Just a bunch of letters thrown together that looks like they're words, but this is supposed to be the defendant, this whole thing right here. There aren't any semicolons to separate it, they're just commas. All right, so, but the other thing is it wasn't filed in the court case, it was filed with Lake County Clerk. Right, it's not filed into the court where this action is supposed to be happening. Well, that was supposed to have gone into the court case. And then here's the alleged complaint. All right, it's in the circuit court of the 5th Judicial Circuit in and for Lake County, Florida, with no case number on it. It says it was filed somewhere, but this doesn't even really say where it was filed at, right? Filing number. It's got the court case number up there. And here's the list of defendants again. And it says it's a verified complaint. Say, oh, God, I'm being sued. What do I do? What do I do? What do I do? All right, well, then we go and take a breath and read for a minute. And we'll see that this is an action to foreclose a mortgage on real property located in Lake County, Florida. And by reason thereof, the venue for this matter is Lake County, Florida. Well, I would say the venue, if venue means a court, then it's the 5th Judicial Circuit of Florida, right? Because that's the general court that has foreclosure jurisdiction. Right? It wouldn't be a municipal court that could foreclose on you. It would be the general circuit court. So borrowers, right? Jacqueline V. Veazey, some middle initial name, person that doesn't really exist, executed and delivered a note and its original amount, and then executed and delivered a mortgage. Supposed to have been recorded in the official records on some page, yada yada. Copies of the note and mortgage are attached here too. And it goes on to say that, well, the plaintiff is the holder of the note and is entitled to enforce the terms thereof, as plaintiff in this is in possession of the original note and is the original payee of the note. Well, excellent. A certification of possession of original promissory note is attached here to and incorporated by reference herein. Now remember, this is what's saying in here, but this has never really been filed into a court case. So we're going to look at what they put in, right? But really, that's really as far as you need to go on reading this. The rest is, about Jackie and about what was supposed to happen and so forth. But the main thing is, well, who's got the paper? And it says the plaintiff does. Well, this is why you could subpoena the plaintiff to see the records, because they're claiming to have them. Because what they put in here, go down and look, right? Certification of original note. I don't know why this is so slow like this. Hang on. Right, plaintiff's in possession. The location of the original promissory note, that's where they're saying it is. Name and title of the person giving the certification. Right, so Dennis Coffey says he's got them. He works as a document processor for plaintiff's attorney. Well, that's who I would subpoena. I'd subpoena David Coffey and tell him I want to see them freaking documents. He doesn't have to come to court. You just want to see the papers that he says he has. Because when we get down here, just another page or two. All right, composite exhibit A, whatever the heck that means. What I know is, well, the loan number's been blocked off. So if this is, a copy of the original, then there is no loan because it's blank. So, you didn't lend me any money, which is what I say all the time anyways, because the name of the bank that they're using in the foreclosure case is not a name of a bank that has jurisdiction in the state to have given you a mortgage. It's not the full legal name of a bank. It's just some words put together that looks like the full legal name of a bank. And while there will be banks that are in the states, registered to do business in the state, to do mortgages and so forth, and it may have part of the name in that's on the name of your documents, it's not exactly the same. Right, so that was blank. Well, the account number is blank. And something above the account number is blank. So this isn't the original, right? This is blank copy. So again, that's why I say, okay, well, then I want to see the original. And I would be putting it in a subpoena as one of the steps in what I'm about to talk about today. But I'm just showing you why I think you should be able to do it. Okay, so that was all that with her case. Now, let's see where we're at, as something to file into the court to make something happen and where the authority comes from to do so. So give me just a second here. Okay, so like I said, there's Florida rules of civil procedure. Every state's going to have their rules of civil procedure. The federal government has its rules of civil procedure. There you are, and here's the rules, right? And so there's two things we're going to be talking about. The first one that comes up is, well, we got this constitutional challenge to a state statute or county or municipal charter or ordinance or franchise noticed by party. Right? Well, franchise could be an office, right? And I've said, since for years now, seems like, that when you go and you look to see what kind of oaths these people have, they don't have the oath that satisfies the 6th article of the Constitution of the United States. And so it doesn't matter what else they put in. They didn't satisfy the Constitution of the United States. They don't have any authority in the United States. So they can't be a state officer because they're not recognized by the United States. And it's simply because they're not, recording the oath that satisfies the 6th article of the Constitution, required by all federal and all state, like legislatures, judicial officers, and executive officers. So they do not do it at the federal level, and they do not do it at the state level. So, hey, we should make that a constitutional challenge. And then if you go down here further, you could have all these other defenses you did, but basically there's a reason that this one's first. Because if you do this first, you won't have to do these other ones. Right? Because they don't have, the people bringing this to the court don't have the authority to do so. And the laws that they said you violated weren't enacted by people that have the authority to enact the laws. They didn't take the proper oath of office. Okay, and then farther down, we start finding these forms in here, right? Here's a form for subpoena. Do take them without deposition. So basically, hey, I want to look at some documents. Right? Okay. Let's go down and read this thing about the constitutional thing first. This is the one that's going to make it go away, right? If something's going to make it go away, it'll be this right here. Did I find it again? Right here. What do you got to do? Constitutional challenge to state statute or county or municipal charter, ordinance, or franchise noticed by party. A party that files a pleading, written motion, or other document drawing into question the constitutionality of a state statute or a county or municipal charter, ordinance, or franchise must promptly file a notice of constitutional question, stating the question and identifying the document that raises it. Serve the notice and pleading, written motion, or other document drawing into question the constitutionality of the state statute, county or municipal charter, ordinance, franchise on the Attorney General or State Attorney of the judicial circuit in which the action is pending by either certified or registered mail. Service of written notice or pleading, service of notice and pleading, written motion, or other document does not require joinder of the Attorney General or the State Attorney as a party to the action. All right, so we don't need to make them a defendant. We just, that's who you're going to send it to. You don't even send it to the other party. You just send it to the Attorney General. And because it's a notice, see it said here you got a pleading, a written motion, or other document drawing into question the Constitution of state statute. So if it was a pleading, it says you have to list all the defendants. But if it's a motion, and so things that are motions are like an application, right? Or other document like a notice, well, then you don't have to file it. You just have to you don't have to list all the defendants, serve all the defendants, none of that stuff. You just have to list the first defendant. So it says in these rules, right? So, that's what it said to do. That's it. Well, let's not do any more. Let's do this first and see what happens, right? That's what I'm saying. Let's not worry about all the other stuff except the subpoena, because we will do those two together. But as far as answering and putting in a motion for like an answer for an order to show cause or whatever, let's first get determined if the people doing what they're doing have the authority to do so. And see if we file it that way as a question, if the people that are going to answer it will give us an honest answer. And before we say they're not going to, well, we have to give them a chance to do it. So that's where I'm at. Let's go give it a shot, see what happens. So here's an idea. Now we'll go through a couple ideas of different things we might try to, what the paper would look like. So hang on a second. Okay, so just real quick then, in Jackie's case, she's in the 5th Judicial Circuit of Florida, right? This is the court that has general civil jurisdiction, right? cases over $25,000 or whatever their breakdown is. And up here it's got this little seal that says 5th Judicial Circuit, State of Florida. Well, I'm going to say, okay, that's what's on their seal. That's what goes at the top of the paper. Right? That's the name of the court. Not these things that they like to call it, but, that's the name of the court. This is what they want to call it in the Circuit Court of the 5th Judicial Circuit in and for Lake County, Florida. Right? Well, that's not the name of the court. It's 5th Judicial Circuit, State of Florida. So, where was that at here? That was, here's an example then, right? It's in the Circuit Court of the 5th Judicial Circuit in and for Lake County, Florida. That's what they put in. And they put the plaintiff, and then they put the, basically the first defendant, and then et al. Right? Case number. Here they don't have any dashes, which, to me it's not the same number. You don't put the dashes in. Well, you just created a different case number. But that's to be expected. That's what they do. There's nothing that they ever put in that's done properly. It's just, they don't do it that way. So, and then one other thing I wanted to show before we go and look at the thing they put in. This is in Jackie's case in December, 6 months later. Chronological summary of proceedings. This is number 85 if you were looking on the list for the court case, number 85, entered December 10th, where it says in here that the judge explains the defendant did not comply with previous order to file answer. Judge signs order denying defendant's application for appointment of a receiver. That's what we were trying to do at the time. As a deadline in citing this date, January 12, 2020, as a deadline to file an answer. Well, so that's what Jackie finally did. She went ahead and filed an answer. And the answer she put in was more like affirmative defenses than an answer. And so it caused some things to happen in the background where, she's not... there were like two mortgages. There was the original mortgage and there was a supplemental mortgage that the county had. Well, the county dropped their mortgage. And there was apparently a lien someplace that had been dropped. But see, this says filed in open court. And, I've never seen that before. First time I've seen it on a piece of paper. I've looked at a lot of court paper. I've never seen one that said filed in open court before. And this is because we applied for something. We did an application. We didn't call it a motion. We application for appointment of a receiver. That's the proper name of the motion you're trying to do. You're trying to move the court motion. But it's not called a motion. It's called an application. It's like doing a précipe, right? It's something the clerk can do. So my point in showing this is, 6 months later, they're still telling Jackie, hey, you never answered this, Jackie. And as soon as she did, well, it was seen as affirmative defenses because she didn't argue the facts that they wanted to argue. She put it in her defense. Okay, well, even before you get to that step was that thing about the constitutional thing, right? Constitutional questions. So let's look at an example of what that might look like. So this is what I want to talk to you about, Jackie, right? 5th Judicial Circuit, State of Florida. That's the proper name. Here's the name of the plaintiff, right? There's the case number. There's the first defendant. Notice the constitutional questions. Now, I plan on copying and pasting this information and putting it into the description of the video if it'll let me do the whole thing, but it may be too many words. I don't know how many words you can do or how many words you can do. But basically this first section here, right, this is all just right out of the Constitution. So I may not put that in there, but you should put that in there. Right? So whereas the third section of the 6th article of the Constitution of the United States mandates that, right, the senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. And whereas an an act to regulate the time and manner of administering certain oaths is the first law passed by the United States Congress after the ratification of the Constitution of the United States and incorporated into the United States statutes at large at 1 Stat 23. And we're going to attach a copy of 1 Stat 23. I'll show you what it looks like in a second. All right, and whereas 1 U.S.C., United States Code, Section 112, Statutes at Large, Contents, Admissibility, and Evidence, mandates that the United States Statutes at Large shall be legal evidence of laws, yada, 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 in all courts of the United States and the several states and the territories and insular possessions of the United States. And we're going to attach a copy of that. So when you're all done, you're going to have a copy of this, this notice, a copy of 1 Stat 23, a copy of 1 U.S.C. 112, and we're going to file it in the court case and give proper notice. So now here's the questions. Are the laws the defendant is accused of offending enacted by constitutionally qualified persons? Right? Did the state, Florida's legislature, did they take an oath to satisfy the 6th article? Because, right, they're members of the several state legislatures. Well, then they have to do it too. And the oath that was decided on by Congress was passed in the very first law of the United States. And in there it says, this is the oath that satisfies the 6th article of the Constitution. I state your name. Do solemnly swear to support the Constitution of the United States. Period. Well, that isn't the oath they take. Right? They don't take an oath that has an I with a place to put their name in it. Right? A-B, you got to put your name in. It has to be your full legal name. No middle initials, because that isn't your name. Your name's on your identification card. Be it the driver's license or, state ID, whatever they want to call it. Well, that's what they had to put on there. They don't do it. And then, are the court's judicial and executive officers constitutionally qualified to prosecute and adjudicate the laws of, should be of Florida, not of the Florida, of Florida. All right, because I kind of wrote this to use for state courts or federal courts. So there's the two questions, right? That's the constitutional question. That's what we want to have answered. And then I said you had to, serve the attorney general or the state attorney for the judicial district. So certificate of service in accordance with Florida Rules of Civil Procedure 1.071. That's the one that talked about doing this. I, Jacqueline Victoria Vesey, certify that I served a copy of this notice upon the Florida Attorney General by registered mail. And then I would just go ahead and take that little strip for your registered mail and put it right there after this. Right? So I have the registered mail number on it. And, you can do that after you have it notarized, right? Just before you mail it, put it on there. But go ahead and sign it, have the notary do their thing, and make sure that it's a sworn and subscribed before, right? That's the type of notary act you want to have done, sworn and subscribed before me this blank day of the year by Jacqueline Victoria Vesey. So you can go on your state's website. You can find, if you put in like state Michigan Notary, let's say like Michigan Notary Handbook, it'll take you to something that'll show you the different things a Michigan notary can do. You may not even call it a handbook in your state, but you'll find something that will lead you to the thing you can use to find the frickin' verbiage you need to have to put on here. And sworn to or affirmed and subscribed before me this blank day, right, by Jacqueline Victoria Vesey. Then you have to have a signature of the Notary Public, state of Florida. So this is the way that they showed it in the state of Florida's law to how to do this, right? So then first you have them sign it, then you print, type, or stamp commission name of the Notary Public. And then they got to check a box, personally known, or produce the identification. And then put it down here. Right now, this is, again, Jackie. Put down your Florida driver's license number. So that you're tying which Jackie Victoria Vesey we're talking to about. The one with this driver's license number is the one we're talking about. Right, so you can have most of that filled out before you went to see the notary. Right, and then after you see the notary, go get a registered mail sticker. Hopefully you already have it ahead of time and put it on there. Right over here. Buy registered mail. Put it on here. Go down and file it into your court case or whatever it takes to file in the court case. You can probably do it online now. Right? And then go to the post office and do a registered mail using that registered mail sticker that you took the small sticker off of. Now it says you can do certified mail. That's all up to you. I'm just saying certified, registered, whatever it is, put the little freaking strip right here that came from the label that you're using as your proof, right? And so that's all you have to do, right? And that's the notice. It would go in, and now they're supposed to answer it. I don't know exactly what that means yet. Well, let's put one in and see what they do. But since we're doing that, it's like, well, let's go ahead and subpoena for the records, whether it's a criminal case or civil case, doesn't really matter. What is it they're saying that you did wrong, and what is it they say that they have to prove it? Well, you want to see a copy of it. So hang on just a second. We'll look at a few more things, and we're about done. Yeah, clean up a few details here. So this is where that portion came out of that I'm using in Jackie's, notice, right? State of Florida, and that came out of, all right, Chapter 117, Notary Public. Well, there you go. So whatever you can find, and here's a notary handbook you could look at, but you have to, it's at Amazon or whatever, but you'll find something that you can use. Governor's Reference Manual for Notaries, there's another one. That's, .com, but let's see if it lets you look at it. Hey, there you go. Duties of a Notary Public. So you can find an example of what to put on there. Not too much problem. I'm just saying you want to have it be subscribed and sworn. You want those two things being done, not just subscribed and not just sworn. You want subscribed and sworn. And, okay, hang on a second. All right, you want to find the website for the General Jurisdiction Court. If you're in some kind of civil case for over $25,000. If it's less, then there'll still be another court. Just what I'm saying is go to the website and see what they use for the name of the court and the place you've been told to go to, because that isn't the name they're going to use on the paperwork that they're filing, because they never really filed a freaking court case in the first place. Now, if you're in a felony case or a misdemeanor, I guess it shouldn't matter, right? You're going to have some kind of document like this that started the action. Normally they're going to arrest you and they're supposed to give you is it called a preliminary hearing? Is that the right word? Where you're supposed to get a chance to look at the evidence against you, but they appoint you an attorney, and he waives your frickin' rights to a preliminary exam. It's just the way they do it. But eventually, that was for a felony I was looking at, but eventually you're going to get a notice to appear of some kind, right? It's going to have who's the plaintiff and who's the defendant. Well, that's, who you're going to put on your document with. If they say this is the name of the court, then so be it. It's the 87B District Court. Right, so that's what would go at the top of the document, like like on the one I showed for Jackie. And then boom, 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 have the statements afterwards. But in that case, in a criminal case, you're going to want to subpoena the prosecutor for whatever it is he says that for whatever evidence he has against you, because you've never had a chance to see it. Your right to a preliminary hearing were waived by the attorney they appointed for you. Okay, so hang on just a second here. I want to look a couple more things, right? I wanted to show these where you're going to find these things then. So hang on. Okay, so one of the things you need is a copy of 1 Stat 23, STAT 23, right, which is in the statutes at large. So Google statutes at large. You're going to find this memory.loc.gov, right? So it's librarycongress.gov. Comes to this page here, and then go here to where it says Browse Statutes at Large, right? Volume 1. And then put in page 23. And there you are, right? Now this is a 2-page document, but there's the first page. And then if you left click on it, it'll download it, but it downloads it as a TIFF, which is some kind of, document. I'm not really sure what that means. What I know is it's not a PDF, right? And I want a PDF. So now I opened it, right? There that is. And I said, okay, well, now I want to have a print it. And I want to print it as a PDF. Right? Yeah, I print it for a PDF. Hey, it's not fitting on the page. All right, well then, change it from landscape to portrait. And go the fit to shrink to fit. Ta-da, there's your first page, right? You can print that out. It'll be the first page of a PDF. But make sure you print out both pages. Okay, so there's your printing lesson for the day. I know that most of the people know that, but some people don't. So it's, this is how you learn, right? And then if you went to 24, or you could have just hit next image. I guess that's the easiest way to do it. Here we're at 23. Go to next image. That didn't work, right? 23. Let's put 24 in. All right, there's the second page. So anyways, we started out here at 23. All right, that's the first page, and you hit next image, and I'll take you to the second page. Do the same thing, click on it. Wait till it downloads. Yeah, make sure you got the right page when it opens up, and something didn't happen. Yep, there's page 24. Print. Change landscape to portrait if it's not fitting in there, or if it's not looking like that. And then shrink to fit. Right? That's what you want. Go ahead and print it. Now you got both pages. You're halfway done. All right, so again, that is on statutes at large, which you get to by Googling statutes at large, find memory.loc.gov, click on it, go here to browse statutes at large, click on it, and it's the very first book. Remember, this is the very first law passed by the Congress. And if you're not going to enforce the first law of your nation, then why would they follow any other laws? So it's a constitutional question because it's the oath that satisfies the 6th Article of the Constitution. Very good. Okay, hang on again. And the other one was 1 U.S.C. United States Code. So this isn't statutes at large now. This is the United States Code, Section 112, which talks about the statutes at large. All right, so I'll show you what I did. Right, you want to find the one that says govinfo.gov, right? 1 U.S.C. 112. Click on it. Go to PDF. Click on it. Give it just a second, and hey, here it comes. Right, once statutes at large, contents, admissibility as evidence. Where it says down here that the United States statutes at large shall be legal evidence of laws, concurrent resolutions, treaties, international agreements, and other than treaties, proclamations by the President, and proposed or ratified amendments to the Constitution of the United States, therein contained in all courts of the United States, the several states, and the territories, insular possessions of the United States. So if it's not in the statutes at large, it's not a law of the United States. right? But that's what they have to deal with, right? So if they say that it's in there, well, then the people that enacted it, did they have the authority to do so? Did they take the oath to satisfy the sixth article of the Constitution? Very doubtful. Yeah, just so I can say I have read it, right? Statute 1, Chapter 1, Section 1, 111, being enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that the oath or affirmation required by the sixth article of the Constitution of the United States shall be administered in the following form, to wit: I, A, B, do solemnly swear or affirm that I will support the Constitution of the United States. Period. Then it goes on further in here to talk about having it recorded and so forth. Now, this particular law, as it applies to state officers, has also been codified in the United States Code as 4 U.S.C. 101. Where it says every member of the state legislature, every executive or judicial officer of the state, shall, before he proceeds to execute the duties of his office, take the oath in the following form, to wit: I do solemnly swear to support the Constitution of the United States. Well, the next section is 102. Same, by whom administered. Such oath may be administered by any person who, by the law of the state, is authorized to administer the oath of office, and the person so administering such oath shall cause a record or certificate thereof to be made in the same manner as by law of the state he is directed to record or certify the oath of office. So you find it, you find out who did it, and you say, well, give me a record of it. If they can't produce a record, then it didn't happen, right? The person that administered the oath is supposed to keep a record. And they haven't taken this oath, folks. It's, that simple. And the oath they do take really isn't the state's oath either. It just kind of looks like it, but it's got errors and omissions in it. Like in Michigan, the governor of Michigan claims to have taken the oath for the state's constitution, but there's a state law that says that a notary public cannot administer the oath to the governor. And you look at the oath, it's been filed with the Secretary of State in the office of the Great Seal, and it was done by a notary public. So, it's not done right at all. Okay, and then so like I said, while you're at it, you might as well file a subpoena too and try to get some records to see if they give them to you. And so, the subpoena form, this is one for Michigan. It's, the interesting thing about this one, it's already got the seal of the state of Michigan Supreme Court on it. Very cool. So, at the, because normally, when I'm talking about, we're the defendant, you'd be checking this box here, putting your name in. Actually, I take that back. You need to fill this out like it's going to the court case that we're talking about, right? So whatever the court case is, it has a plaintiff. It's probably the people of the state of Michigan, or it could be the name of the bank, civil or criminal, right? And then we're the defendant by whatever name they're using. Right? I just put my full legal name in. That's all I would put. I wouldn't care if it's civil or criminal. If they're acting like I'm going to court, I'm going as Robert Allen Redlewski, period. I know you're not going to call me Mr. Right? A Mr. is a lower class gentleman in the British system below an Esquire. All right, so don't ever let them call you Mr. All right, but anyways, whoever it is against you, and then who are you going to send this to, right? Who is it that you're filing a subpoena against? Well, I would say you file it against the attorney for the plaintiff, because they're the ones that are holding the paper. Right? And, they'll have their name and information on the, whatever the document is that you're looking at. Like, do I still have that up here? Where was that? Right, here's a notice, right? This guy here, he's the plaintiff's attorney. Well, that's who you would ask. Right? This guy here has to answer. And let me see if I can find one here. Jackie, hang on. All right, remember in Jackie's case, they had a certification of original note where they certified the location of the note and the name and title of the person giving certification. Well, that's who you're going to address your subpoena to. Right, but as far as the address of the place, it's this thing called XL Legal PLC. Yeah, so whatever that person's name was, at XL Legal PLLC, right? The designated email address is that email address. So if you could have done it by email, then that'd be great. But if you need to send it to them, then here's their mailing address. Right? They're the attorney for the plaintiff. So that's the... Where did it go? Yeah, that's who the to is, right? And then what are you doing? You're ordered to produce, permit, inspection, or copying of the following items. Right? Check that box there. You don't have to check any other ones. Who's the person representing the requesting the subpoena? Well, that would be you, right? Your full legal name, your phone number, address, da-da-da-da. And that's how you have to file it. And then the judge or the clerk has to okay it. Right? Then they got the certificate of service, which has to be done in a particular way, and there may be some fees and so forth, but whatever it is, that's how you're going to get to look at a copy. Right? I don't really know how to do this part yet. I'm just saying, well, fill all this out, take it down to court, see what's next. So, again, Jackie wouldn't be using this one for her case because she's in Florida, right? This is the one for Michigan. But they did have something in Florida, because if you go Florida subpoena form, right, you'll find, well, form 1.922, subpoena duce tecum, without requirement to show up or something like that, which is different than this one here, 12.991, which is for family court, right? This is a civil matter. So you got to make sure you got the right subpoena. But it looks something like this. Right? Got the state of Florida, who is going to, you're commanded to appear on or whatever, and to have with you those if you fail to hang on a second. Yeah, let's do it this way instead of looking at some third-party site. Let's get the Florida Rules of Civil Procedure. Right, subpoena. And the form number was 1.922, right? So basically, scroll through here. Eventually, you get past the rules, you start getting to the forms. And you got subpoena at trial, subpoena for trial, subpoena for deposition, subpoena. I mean, there's all sorts of subpoenas. Let's look at this one. Right, subpoena without deposition. When a witness has an option to furnish records instead of attending deposition issued by clerk. Well, okay, I really don't want him to be deposed. I just want to see the frickin' paperwork. Right, so you're going to copy this blah blah from here, put it onto a document, take it down to the court case, down to the clerk. You are commanded to appear in at something and to have with you at the time the following. Right, so that's where you'd put in there the mortgage, the original note, and the mortgage. Whatever it is they said they had, right? Or if it was a criminal case, all the evidence the prosecution claims to have against me. Something like that. I mean, I don't know exactly what to put in there. We're just saying you got to put something in. So you're looking for the evidence that's being used against you. These items will be inspected and may be copied. You will not be required to surrender the originals. You may copy or comply with the subpoena by providing legible copies of the items to be produced to the attorney whose name appears on the subpoena on or before the scheduled date of production. You may condition the preparation of the copies upon payment in advance of reasonable cost. Okay, you may mail or deliver the copies, right? So that's what we're trying to have them do, something like that. Dated on, you got to put the date, put the name of the clerk as the clerk of the court. Right, this is what the clerk is going to do, and you would put your name here and attorney for, put your name there, right? That's who you are. Get rid of the Florida bar number, you don't have one. Right, but if you're pro se and you're representing yourself, then you'd be the attorney for yourself. Now, if you hired an attorney already, then tell him to put this in. All right, say, I want you to file a subpoena and get the fucking evidence that's being used against me, because I ain't seen jack. But I don't know if they're going to do it. But even if you do have an attorney and you can't get them to do it, well, then you do it. Just go put it in, see what they do. So, some kind of subpoena without the need of them showing up. You just want to see the records. That was kind of my idea. Okay. So then, because I was going through this today, trying to figure out all the little pieces and stuff, I filed something into a federal court case that I want to talk about, because I like to make public record of that kind of stuff. So give me just a second to show you. Right, so now this is, me trying to act like the United States, not as somebody's attorney or as a representative of any of the parties or so forth. I'm representing the United States, and I have an interest in this particular case, or any case I want to have an interest in, especially if it's in the U.S. District Court. Right? Should be United States District Court. So you can see there, they're not using the proper name of the court on the docket. But if you go to, right, this is in the District of Florida, it's United States District Court, District of Columbia. No, it's not Florida, it's in District of Columbia. Right? It doesn't say United States District Court for the District of Columbia. It's United States District Court, District of Columbia. So that's what I'm putting on the top of the paper. And, I have a Pacer account, so I'm able to track these cases. And this particular one against Christopher Warren-Aguirre, he's a major, right? He's an active duty major in the Marines who got caught up in the ship from September 6th, from January 6th, right, at the Capitol, and they're charging him with all these different 18 USCs, right? That's what these are. Although they don't have, these don't have the full number in it. It's like, well, is that the proper way to cite U.S. code? Is 18 colon with some numbers behind it? Or are you supposed to put 18 U.S.C. Funny little sign like a money sign, and then whatever the number is. Because that's how it says to do it when you look at, citations. But nevertheless, these are all the different pending counts against the major for this particular court case number. And on here, then it had, right, the plaintiff, USA, not United States, not U.S.A. USA, which is not the United States. But it does have, somebody acting as an attorney, saying that they are the designated attorney to be noticed, designation assistant U.S. attorney. Well, very good. So I know that the U.S. Code, or excuse me, the U.S. U.S. Rules of Civil Procedure, right, probably have the way to do it in there. But I really didn't do it that way. All I did is I did it basically how it was showing to do it in Florida. And what I filed then was this here. That, all right, United States District Court, District of Columbia, United States of America versus Christopher Warren-Aguirre, date of birth, X. Now this is the way they have it on his complaint, right? That's his date of birth, XXXXXX, with this court case number, which basically said the same thing. Whereas the third section of the 6th Article of the Constitution of the United States mandates what? Right? There's the third section of the sixth article. Whereas an act to regulate time and manner of administering certain oaths is the first law passed by the United States Congress after ratification of the Constitution of the United States and incorporated into the United States statutes at large as 1 Stat 23 attached. And whereas 1 U.S.C. 112 statutes at large contents, admissibility and evidence mandates that United States statutes at large shall be legal evidence of laws in all the courts of the United States, the several states, and the territories of the United States attached. So questions. Are the laws the defendant, Christopher Warren Garris, date of birth, bunch of X's, is accused of offending, enacted by constitutionally qualified persons? Are the court's judicial and executive officers constitutionally qualified to prosecute and adjudicate the laws of the United States? All right, certificate of service. I, Staff Sergeant Robert I. Waluski, do certify I serve this notice upon Jennifer M. Rozzoni, Assistant U.S. Attorney, designated as the attorney to be noticed, at email address, yada, yada, yada. I certify under penalty of perjury the foregoing is true and correct, executed on July 11, 2021. Right, there's that. Right, here's the 1 Stat 23. Here's 1 U.S.C. 112. In the window it goes. Now in federal court, because they have these COVID restrictions, COVID clerks office operations information, I had intake here, right? They gave this email address. Motion to file under seal. Motion to proceed under pseudonym. Sealed miscellaneous applications. New civil cases, new miscellaneous cases, and general pro se filings. Yeah. I figured I would put it in the intake instead of putting it into the criminal filing only, which I guess I could have, but we'll just see how it goes this first time around. And so I put it in today, and the thing with PACER is if they're going to accept it, it will show up on PACER. Down here is some entry at some future time. So if you have access to PACER, want to follow along, it's 121 CR 00382. But other than that, just as soon as I hear something, I'll be doing a video on it. But, that's what I had to share today, right? Let's try doing what it says to do and ask a constitutional question to see if what they're doing is constitutional. And I'm hoping to get Jackie and a few others to go ahead and just file the paperwork and see what happens. Right? And whether it's 100% correct or not, I'm not really that concerned about. Right? If you need it to be 100% correct, then I'm not the person to listen to because I don't ever try to get it down to 100% correct on the first swag. I want to put it in and see what they say. Because I'm sure that they'll give you some kind of answer. It's just what will they tell you? And if they tell you that some part was wrong, well then fix it and put it back in. So very good. That was the plan. Right? Plan the work the plan. That's the way we do it. Notice of constitutional question and subpoena. On Sunday, July 11th, 2021. You all have a great day now. See ya.